Good evening. It's my pleasure to be here with you on Facebook Live. This is a live broadcast, which you can also see through Twitter, through YouTube. You can go to the app of Noticias Telemundo, online at Noticias Telemundo, and of course on Facebook. Welcome, welcome, and please share that this is information on a weekly basis about immigration. So we will answer your questions, and I like to start, and sometime during the middle of the segment, I like to start with whatever has happened this week that is of importance for the immigrant community. So with today's news, we have that ICE has now, it's not new, but it's just being noted by the media that they're boarding buses that are going across state lines within the United States. It happened in Florida, and a woman that had an expired visa, she entered legally into the United States, but the visa was expired, or her time or permit to be in the United States had ended and expired, so ICE boarded the bus and detained the woman. My recommendation, obviously in this case, is to never, ever present fake documents. Also, remember, you have the right to remain silent. That's a constitutional right that every person within the United States, whether they be documented or undocumented, has. So it's best, if you are out of status, to remain silent if you are approached by an ICE officer boarding a bus or while you're in transit in a bus. My recommendation is also, if you're out of status and you must commute from one place to another, it's best to take a plane. It's not 100% safe, but it is safer than commuting through a road, because immigration does have many stops along roads. I'm in Los Angeles, but they have stops. Many people commute to Arizona or Texas. There are definitely stops along the way. So my recommendation is, it's best, if you must commute within the United States and you have no status or are out of status, is to take a plane. There is immigration presence at airports. However, the likelihood of being detected is, in my belief and experience, smaller than it is when you're commuting by car or by train or by bus crossing interstate lines. So that's the latest. It seems like ICE has made a comment on this and said that this is something they have done in the past. It's not out of the ordinary. It's not just because of the new administration. However, it seems to be more noted, or it's perhaps the numbers have increased in the recent past. So again, this is sad news that is happening in the United States for those that are hopefully seeking to get immigration status, even though they may be out of status. Many people that have entered out without status, or their status has expired, are seeking to immigrate through some means. And I'll remind you that sometimes these lines and waits are very, very long. If you have a sibling that's a United States citizen and you've been petitioned by him or her, the wait can be anywhere from, 13 years for Central and South America and Europe, and it can be up to 20 years plus for Mexico. So many people, even though they're out of status, are seeking to legalize their status, but the laws, unfortunately, the quota systems and the laws are so outdated that the waits are ridiculous, like in this case that I just mentioned, 20 years plus. So that's the news on ICE boarding buses within the United States for people that are commuting. And sometimes, and I want to stress, it's not just interstate. It could be within the same state, but if there's a checkpoint and ICE boards, they will question you. Remember, remain silent. Do not present any documents that are not valid. And do not carry any documents that are not valid, because if you do get stopped and detained and later questioned, they'll find these documents, and then you may even have criminal liability for use of fake documents, besides having issues with immigration. So the situation just metastasizes. Very well, I'm ready for questions. Every Tuesday we answer questions, and I remind those, and I'll just shift to Spanish for a second. Los jueves en español a las 7 de la noche hora del Pacífico, 10 de la noche hora del Este. So the same segment repeats in Spanish, on Thursdays, 7 p.m. West Coast time, 10 p.m. East Coast time. So this way we capture and we attempt to help and give immigration information to people in both languages.
Thank you so much. And the first question is from Gabriela. What happens if I apply for DACA right now? Will it be very risky?
You don't tell me, Gabriela, if this is your first time or if you're renewing. If this is your first time, it's one big question mark, because if it is eliminated, you've given immigration all of your information, your fingerprints, information belonging to your parents as well, because they do ask information about your parents. So it is risky in that instance if this program is terminated or ends, which is, there's a risk of that happening. As you probably have heard me say last week, there are 10 states that are suing the administration if they continue to extend DACA for Dreamers. And also within the White House, there's back and forth of we want to protect these young children that came here innocently as children, and then we have to end the program. So we don't know where this is. There is talk of ending it, so my concern would be of giving them your information. However, if you've already applied, I definitely recommend that you continue extending your DACA because they have all your information anyway in the system. Now, there's another little side note to this, or a segue. Congress has, both the House and the Senate, proposed laws to protect or somehow bridge the DACA that now exists, that's an executive order made by President Obama, so that if it ends, the House and the Senate are they've introduced bills and they still have to vote on them, but if they pass, they would bridge the status from DACA for the young dreamers to something else, and this something else could even lead to permanent residency. So there's an argument for, yes, Gabriela, apply, because if this law passes the House and the Senate, then you will be happy that you had introduced some kind of paperwork in the past, because then this will bridge whatever it is you had in the past. So there's both arguments, the pro and con. It's impossible to, of course, have a crystal ball and know exactly what's going to happen with DACA. This is a personal decision, and if you're uncertain, I recommend you seek consultation with an attorney that is a specialist or has a lot of expertise in immigration, because every case is different. Maybe you go to a lawyer and they'll say, wait, you've got X, Y, and Z in your past, and it wouldn't behoove you to apply for DACA. So if you have anything in your past, whether it be immigration contact or criminal contact, police contact, you may want to seek counsel before applying.
Joyce. I am Venezuelan. I came in September 2009 with the F1 visa. My country blocked the foreign exchange, so I couldn't continue my studies. I applied for an adjustment status and it was denied. My parents are residents and my brother is a citizen. Can I apply for a provisional unlawful presence waiver?
Yes, I'm sorry to hear what's going on in Venezuela. We're all very well aware of the issues that the country's going through, and that's heightening a lot of people from Venezuela for applying for asylum as well, and many people being considered for asylum because of the situation that's going on currently in Venezuela. However, in your case, since you've been here for a while, and I don't know if you're out of status and how long you have been, if you are still in status with your visa, the student visa, then perhaps you won't need a waiver when you're ready to get a green card through either your sibling or your parents. Now the wait, and you don't tell me your age, I assume you're over 21. The wait right now for Venezuela is November 2010. That means that your parents, if they were to apply for you, you would have to wait 7 years to get a green card through your parents that are lawful permanent residents. Through your brother, the wait is from 04. That means that's from 04 to now, 2017, that is 13 years of wait. I would even recommend that you file both applications, one through parents and one through your siblings. There's no problem with having two applications at the same time. You never know if one priority might move faster, or the laws may change, or they eliminate a priority. You always want to have a backup plan. Now, if you do have to leave and go abroad to get your green card and you have illegal presence, you'll be able to get a waiver. It's called an I-601A within the United States because you have parents that are lawful permanent residents. So that's a little bit of light at the end of the tunnel in your case. Best of luck.
The next question is from Norvin. What happens if someone with a tourist visa came and stayed and now would like to leave the United States without papers?
And now, can you repeat the last part, Fernie? He has a visa, it's out of status, and now he'd like to what?
Leave the U.S. with no papers.
Great. Okay, well, unfortunately, now, and I don't know how long ago you came, now there's a system within immigration where they track, of course, when you entered and when your date of expiration is to come. So they will have it in the system. They've been detaining, actually, people that came in with some kind of status, whether it be a tourist visa, a student visa, a work visa, or some kind of business visa, and they overstayed, well, immigration has been tracking some of these people that are out of status and going to pick them up. Now, in your case, you want to leave. Where I see an issue, I don't think you'll have any problems at the airport as you depart and you're leaving the country. My concern is if you want to come back to the United States in the future and you present a visa, they're going to see that there's no record of you departing on time, and that may be an issue for them allowing you to come in. They could send you back and not allow you entry if they discover that in fact you left tardy or late.
Patricia, when someone is deported and it's been 30 years and they're back in the U.S., can they reapply for residency? Married 4 years with a U.S. citizen and 2 children.
Good. Thank you for all the information. And you tell me that you were deported 30 years ago. And 30 years ago, I was practicing law 30 years ago. So I venture to say that it was probably a voluntary departure and not a deportation. Now deportation, or the definition, or who can give deportation, has expanded. Before it was only an immigration judge in immigration proceedings before a court. Now, an immigration officer, when you're coming in or you're stopped in the U.S., can actually expeditiously remove some people and deport others. So if it was 30 years ago, the first thing I would do if I was your attorney is I'd run your prints and I'd request a FOIA to request documents from what happened 30 years ago so that I am certain that it was a deportation or was it a voluntary departure. Because they are 2 ways of leaving. However, one is forced and has consequences, and the other one is that you're leaving voluntarily and has some consequences, but they're not as egregious as being deported. So first, we need to do some investigative work in your case, and I recommend you see an immigration attorney. I know you're married to a United States citizen, but that doesn't cure everything. You can apply through him, and you can still be denied, and you may have to go back home to immigrate, and I would hate for you to leave and then find out there that you have a 10-year bar and you can't immigrate, and you filed all this paperwork just to be deported again. So in my recommendation, I would say go see an immigration lawyer, and then have them do some investigative work that'll take a few months, but it's best to do that before you file anything.
All right, Nico, my question is, if I put an application for citizenship and I passed part of the test and the second part, I had to go back. However, I received a letter with my new appointment and I sent it so that I can get it rescheduled. They did not respond and wanted me to pay another $600 to appeal the denial due to a no-show. What do you recommend?
Oh my goodness. Well, if you didn't show, of course, they have a right to ask you to file all over again, and it's not even, I would not appeal. Now, if you have proof that you didn't show and you requested a written extension and a reschedule, you may be able to appeal and fight it and win. But if you did not keep any evidence that you asked for an extension and they think you just basically no-showed, appealing and paying all that money to be denied and then later having to apply again and pay $700+ to reapply, I think it's a waste of money. So again, I would go see an immigration attorney, tell them the whole story, show them the evidence of what you did and what you have, so that that person can decide if it's best for you to appeal because it's a winnable appeal, or it's best for you to let sleeping dogs lay, as they say, or lie, and then reapply. And no shows would not affect you to reapply. And study hard so that you don't have the same issue the second time around.
Thank you so much. And this is a long question, a little bit complex. It is from Lorenia, and she mentioned that she's been asking for a few weeks now. So here we go. In 2013, I entered with a tourist visa, and I got married immediately. My husband started my residence process. They took my prints and medical examinations, and instead of my tourist visa, they gave me a credential not valid for re-entry to the country. But in 2014, for the appointment of the interview, I had a restraining order filed against my husband for domestic violence. They told me that I could be a petitioner for the Visa U or WAWA, but at that time I was scared and I just wanted a divorce. Today I have a year married with the love of my life, but another American citizen. We live in Rosarito, Mexico. 2 months ago, he applied for my residency through the I-130, and my question is, will it affect my actual process not to have notified my last departure out of the USA? The U or Wawa visa that they're mentioning, was it dismissed because I never showed interest? And should I mention all of this history to my future interview at Ciudad Juarez?
Excellent question, very long, and I tried to follow it as best I could, and I didn't take any notes, so here I go. I'll answer. Basically, the fact that you left and abandoned a U or a VAWA application, for those that you don't know, many new viewers, perhaps a U is for victims of a violent crime, and VAWA is a Victims Against Violent Crimes Act that was passed by Congress, and you were eligible to apply for both. As a matter of fact, from Rosarito, Mexico, you can apply for a U visa again, but that takes several years, so you might be better off applying through your husband. Now, what I would do is I would get a compilation of everything, your visa when you entered in 2013 or 12, then your interview that you had later, the divorce papers, the documents that show that you were a victim of abuse. All of that has to be documented, and I would even tabulate it and have it, and I would take it with me to Ciudad Juarez to the interview. However, I would not go to the interview to Ciudad Juarez, although you're married to a United States citizen and have every right to immigrate, until you've seen a U.S. immigration attorney. I know you're in Rosarito. Many attorneys do Skype interviews from the U.S. to many parts of the world or over the phone. And what you would do is send copies of everything you have to that lawyer so that everything can be reviewed. And you want to make sure that there are no negative notations in your file with immigration. So you could also ask for a FOIA, that's a Freedom of Information Act, which you could get copies of everything in your file at immigration, or mostly everything. They do keep a few copies, a few blank sheets they'll give you, and you don't know what they've kept. But I would recommend you do a FOIA of your applications, all of them, the U, the VAWA, the green card through your husband, to make sure that there are no discrepancies and no negative comments by immigration that could affect you at the interview in Ciudad Juarez. I don't think you'll have a problem. However, I never send someone from wherever they are. I know you're in Mexico and you would just be going to Ciudad Juarez, but I never send anybody to the interview without reviewing everything in their file from their current case and any prior applications. You also want to be prepared on how to answer as to each one, because the consul may ask you questions. Although you're immigrating through your United States citizen husband, they can ask you questions about your first marriage, about the first application, about the VAWA, about domestic violence, about the U, and you don't want to be like a deer with headlights and not know how to answer the questions, because you may not understand, and you can ruin the chances of getting approved. So you need to be coached by a lawyer before you go to that interview. And I'm so glad you kept insisting, and I beg that all of you, that I know many people watch this every week and try to get in, and there's only so much time and we can't answer all the questions, but I really appreciate that you were persistent, and I'm very glad that I was able to answer your question.
Thank you so much. Cece. Hi, attorney. I've been 12 years in the country, came in illegally. I'm 26 years old and single. I currently have a work permit from DACA. My mom is resident for about 3 years, and I would like to know, what do you recommend?
I definitely recommend. Your mother's been a resident for 3 years. I hope you haven't been sleeping on your rights. I hope that your mother has petitioned for you, even though you have DACA. And big shout out to anybody that has DACA or TPS. Warning, if you have that, please don't be complacent and think, well, I have a work permit. I'm semi-legal. I'm not going to do anything else. This person that's writing us now, whose question I'm answering, has a way of getting a green card through their mother. So you should be filing an application through them as well, and take them in tandem. I like to see people with TPS, that's for Central Americans, or for DACA young youth that came as children, and also at the same time parallel an application that will turn into a green card. So my recommendation is continue with the DACA, continue renewing it, and also please, I hope you filed, and if you haven't, file something through your mother now.
Rivera. Parents with disabled children, can they apply for a green card?
So I heard Rivera, and can they apply for a green card? What was the first part?
Yes, the person is asking if parents with disabled children can apply for a green card.
Thank you. Okay. There is a lot of fallacy on that. I have colleagues that I do not respect that advertise do sensational appearances on TV and say, oh, they had a child that was ill and they got a green card. They fail to explain that the numbers nationally of these types of cases, not with one lawyer, not in Los Angeles, not in Miami, not in New York, but nationally as a whole, there's a percentage of 1 to 3% of these cases are granted every year. So many lawyers are filing political asylum applications, and I call them Mickey Mouse because there's no basis for them, to get them into the system, to then be put under deportation proceedings, to then pursue the defense of filing what is called a cancellation of removal because they've been here more than 10 years, they have excellent character, no crimes in the past, and they have a child that's born in the United States, or a spouse that's born in the United States or is a resident, or parents that are born in the United States or are residents, and there's something wrong with them health-wise, mentally, and they'd suffer extreme hardship if the person that's applying for a green card were deported. You have to file this case with, not the Immigration Service, with an immigration judge. Guess who's at the hearing? Your lawyer, you, the judge, and a trial attorney that represents the Immigration Service and ICE, trying to tell the judge, don't give them a green card, they don't deserve it. And the percentages are 1 or 3 out of every 100. I'm not saying don't apply, but I'm saying please seek the advice. How we say seek the advice of 2 lawyers? I would seek the advice for this type of case at least 3. Because some lawyers are interested in turning you in to charge you thousands of dollars to file for this type of relief, and they don't tell you that 97% of these cases can be lost. Now, some cases are really, really good, where a child is so disabled and they are on medication and they need surgeries for the rest of their life that it might be worth a shot, but you have to tell the client what the odds are, and you have to tell them what could happen if that judge, who has total discretion to say yes or no, it's not a law that says, oh, you show you have a disabled child and you get a green card. The judge can say, I always say, they can just hold their wrist on their waist and say yes or no, and the law allows them that discretion. If they say yes, you get a green card. If they say no, you have to leave the country with your child, or you leave your child behind. So yes, I've won many cancellations of removal. I tend to take these cases if someone has already been detained by immigration and they are going to be deported, and then I use it as a defense because they're already in the system anyway. But I'm very, very cautious of who I turn in. I seldom do. I think these cases are very risky. They're very expensive, and you must be honest with a client and let them know that the chances of winning are slim and what can happen if they lose.
Vanessa. My mother just applied to renew her green card. She did her fingerprints and they extended her card for a year until her process is finalized. Is it safe to travel out of the country?
Yes and no. If the card's expired and she got some kind of extension, yes, she can travel. If she didn't get an extension, and some of them there's a sticker on the card, I recommend you get a valid passport from your home country. You go to immigration with the receipt that you've applied for a new card and extension, and they'll put a stamp on your passport with which you can travel. So don't just travel with the proof that you've extended it and leave and then try to come back, because although you'll be allowed in, most likely they'll check in the computer, they'll check your prints, your name, your date of birth, the old card, and they'll let you in, but you may be stuck at the border or at an airport for hours until they verify everything. So it's best to get some kind of proof that is valid for traveling and to come back in. Very well. I have another topic, and a lot of people are asking how to contact me, and I have a new website. It's almarosanieto.com, same name, same info, same address for the website, but it has new info, and we've just uploaded about 20 new videos that I hope will be a benefit for people that have, and they're in different areas, so hopefully they will serve to shed some light on this complex area of immigration law and guide you to seek counsel and seek immigration advice so that subject and the other topic is, this is for Mexican nationals that live along the border. And again, I know many people join us on a weekly basis that are new. There are special visas for people that live on the border, and they get issued little cards that are called border crossing cards. They're issued by the American Embassy in the different points all along the Mexican border with the U.S. And they allow people to come shopping, to come to visit family within a certain amount of miles from the border, and they can come and go frequently because they have these cards. And other people have green cards, and that they're no longer green, but they're called green cards. They're lawful permanent residents. They're allowed to live, work in the United States, and travel in and out of the United States as well. Well, there's a snag. This just came up, and media has covered it as well, that people with cards, whether they're border crossing cards or their residency cards, that have a cut, they're starting to tear, they're starting to wear, they're starting to peel, they've been folded, they've been cut, they're starting to get eraser marks on them, they're damaged in any way. The Border Patrol officers at the border are saying, we're not going to let you in until we verify that you are the right person, because this card could have been altered, and they're confiscating the cards and making you pay for a new one, either at the border or making you file at the American consulate abroad in Mexico. So this is something new. So if you have a card that is damaged, please look at the card. First, see if it's not expired, because many people have been living here all their life and they have a green card. They don't even look at the dates, and many times they're already expired. So check to see if it's expired. If it's damaged in any way, you may want to renew it. If it's a border crossing card, you renew it at the American Embassy along the border. And if it's a green card, you can renew it online, and as of a week ago, on your mobile app. And it's $455 to renew a green card if it's expired or if it's damaged in any way. Why do you want to do this? Not because I want you to spend more money, but because I don't want you to be stopped at the border for hours waiting until they investigate because the card is damaged in some way. So that's my next piece of advice. And I know it's costly to renew them, but it's better than spending every time you come 2, 3, 4, 5 hours at the border until they check your information. Very well. Do we have any more questions?
Yes, we do. There is another question from Melly. She's asking if she can legalize her husband-to-be. He entered illegally from Nicaragua, and he doesn't want to be sent back.
Okay. There are, very briefly, 3 groups of individuals that can immigrate within the United States. That means that they go to an immigration office in their city where they reside in the 50 United States. They don't have to go to the American Embassy in their home country. Those are that they have a husband that's been in the military, is a veteran, or is currently in the military. That's called parole in place. They entered legally, which in this case they didn't, some kind of visa, some kind of permit, a parole of some sort, but they entered with a stamp on their passport. And those that are covered by a law that ended many years ago called 245I, it ended April 30th of 2001. And if somebody applied for you, an employer, a sibling, a spouse, a parent, a child, you had an application in immigration and for some reason it didn't get concluded, but you still have that protection, it's called 245I, you're allowed to immigrate in the United States by paying a $1,000 fine. So those are basically generally the people that can immigrate when they marry a United States citizen in the U.S. You tell me that your husband entered from Nicaragua without status, so if he doesn't fall into any of the other 2 categories, he must go to the American Embassy in Managua, Nicaragua for his interview. But the good news is he can ask for a pardon for living here out of status, and the pardon is an I-601A. It's filed in the United States, processed in the United States, and he goes a week to 2 weeks to Nicaragua to the American Embassy for his interview and for his visa. Then he comes back in legally. If it's done with a competent attorney, it should be a seamless case. Waivers are a little difficult to get, so you have to show that you would suffer extreme hardship if your husband is not granted that waiver. But it's doable. I send many people abroad. So don't be afraid. It's more, I would be more afraid to live in these times under this administration out of status than trying to get a green card through my spouse at the American Embassy in my home country, advised by a competent immigration attorney. Best of luck.
Thank you so much. And the last question is from Rocher. Hi, I'm 29. I have TPS since I was about 10 or 11 years old. I dropped out of high school to help my parents and went back to school to obtain my GED during my late 20s. here in the U.S. I'm not married and would like to know what would benefit me more to move closer to a permanent residency status.
Well, you tell me about everything you've done, which is wonderful, and I applaud you. Helping your parents, laudable. In our communities, of course, we're very family-oriented, so I applaud you for that. And then going back to school, number one, ACE. However, those qualities that are very human qualities, unfortunately, don't give people a green card. You must have someone to apply for you. You tell me that you have TPS, that you're single. If you were to marry, and I make this big parentheses, for love and affection, you marry a girlfriend, she's a citizen. Because you have TPS, now you don't tell me where you live, there was a Ninth Circuit Court case that covers a lot of the West Coast states that allows people with TPS to immigrate in the United States without having to travel abroad if they marry a United States citizen, or they have children over 21 that can immigrate them. So in your case, being that you're single, at least that's an open avenue for you if you fall in love and you marry for love. So that would be a way, and you would, if you live in the Ninth Circuit District Court, in the district of the Ninth Circuit, you would be able to immigrate without leaving to your home country. So that is with the little information you gave me about family ties or what you have going for you in terms of parents or siblings. Now, if you have any other family that is a resident or a citizen, you may consider filing an application through them. And I would look to seek counsel right away, because I don't want to frighten you, but there's just noise saying that TPS may end, and hopefully it will not. But if it does, you want to have something. You want to have your ducks in line and something so that you're ready to proceed on a new application in case it were to be denied. Best of luck as well. Well, I think that was our last question. I remind you, we're here every Tuesday in English and every Thursday in Espanol, different times, 7 p.m. West Coast time, 10 p.m. East Coast time. It's been my pleasure and my honor to talk to you and answer your questions. Please don't get discouraged if you didn't get your question answered. I'm here every week live, and hopefully next week we will. Hasta la vista. Hasta la próxima. Thank you.